Good morning. If everyone please join me in rising for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. This time I'm going to open the executive session on House Bill 113, and I recognize Representative Rhodes to make a motion.
Thank you, Mr. Chairman. I would like to retain House Bill 113.
Is there a second?
Second.
Who seconded that? Sounds like proof.
You ready? The motion was by Representative Rhodes and seconded by Representative Provo. Would you like to speak to your motion?
Yes, thank you, Mr. Chairman. After talking with a lot of the stakeholders in this particular bill and some members of the general public, there's some information that has come forward that we think we could actually address in this bill. And additionally, some of it may be able to be made in the rules and not actually have to be in legislation.
Would you like to speak to your second, Representative Pro? Would anyone discussion? Representative Stone?
I'm all set, Mr. Chairman.
Anyone else?
No, I'm good.
Okay. Initially, I liked this bill, and I still kind of like it, but it's been brought to our attention from the law enforcement community that they would like to have a chance to look at it a little bit further. There was some difficulty in getting feedback from all the stakeholders, so rather than foist this upon them, I'd like to give them a better chance to look at it and give us more input. So by retaining the bill, it doesn't kill it. We'll still act on it by October, and we'll come up with something. Without further discussion, I will ask the clerk to call the roll. And the motion is to retain.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Lynn, Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Gathright, Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Brennan,
Yes.
Representative Wheeler,
No.
Chairman Roy.
Chair votes yes.
Motion passes 19-1.
The bill is retained. This time I close the executive session, House Bill 113. And I open the executive session on House Bill 156, just for the edification of the committee and those in the gallery here. I'm skipping over 135 because there's an amendment coming. It's not here yet, and we'll get into that and discuss it when it arrives. So 156, and I recognize Representative Janvrin to make a motion.
Mr. Chairman, I actually was just on the phone with, OLS about 5 minutes ago. They're redrafting my amendment, so I should be getting an email very shortly.
Yeah, we seem to have an OLS logjam this morning. In that case, I'm going to recess the executive session on House Bill 156, open the executive session on House Bill 328, and recognize Representative Pratt for a motion.
A motion on 328 is ITL.
Is there a second?
Second.
Seconded by Representative Mannion. Representative Pratt, would you like to speak to your motion?
Well, this bill is in regards to a different kind of drugs that we've been looking at all along here. This is a Lazeric diethylamide mescaline, which is LSD, and I'm sure I butchered those. And there's another one, PCPs here, or any analogs similar to these drugs. These drugs don't really have a beneficial outcome to the people that take them, and I just want to ITL the bill. Thank you.
Representative Mannion, would you like to speak to your second?
No, I believe you covered it. Thank you.
Further discussion? Representative Muse.
Thank you.
I plan to support the ITL, but one of the things that I do want to point out is that these particular substances have increasingly been shown to help people who have mental health issues, especially folks who have PTSD. In other states, there are legalization efforts that have either succeeded or that are in progress. And the people asking for this aren't drug users on the street. They're people like veterans and police officers. Unfortunately, when bills like this come to our committee, we we have to take a very narrow focus on legalization and how things fit into the Controlled Drug Act and what the potential is for harm across the board. The sad thing is that substances like this increasingly are being recognized for the potential for good that they have. And under the supervision of a medical doctor or some type of clinical setting, I believe they could be tremendously helpful to people. But straight legalization at this point is something that I don't think we should consider because of the potential impact on younger people and people who may not understand what they're taking. So with that said, I do plan to support the ITL, but for very different reasons than my colleagues. Thank you.
Thank you. I would add that I actually, it would be the same reasons as I. I think that there are potential benefits in some of these, but they need to be medically vetted and not experimented, but at least trials in a more controlled setting before they're just, we discuss just cutting it loose to the public at large. Representative Bolden.
Today I learned that 5 minutes and Amanda's standard time is 20 minutes. I'd like people within New Hampshire working in science to be able to study the benefits of this, and I think that's why I'll be supporting the bill.
Thank you. Representative Wheeler.
I think that, we're here to discuss the criminalization of these substances, and I think that through the conversations we've had over the years, if some of us have been on the committee for years, about the legalization of these substances has proved that the criminalization does nothing but allow the law enforcement community to go and pick people up for holding substances that have no real harm to the society at large. And frankly, I think that, I won't use the term war on drugs because I don't think that necessarily, like you said, Mr. Chairman, means much anymore. But I will say that the criminalization of these substances has played a serious role in breaking up communities across our country. And I think that if we want to move forward, having them, as Representative Bolden said, study the substance, be able to experiment with it, as you said, Mr. Chairman, I think we have to legalize it. And I think I think starting from that standpoint is much better than continuing to stigmatize it when, frankly, this is a substance that again has no real harm and does, by the studies, have serious benefits.
Thank you. Representative Newell.
Don't worry, I'll be quick. Thank you, Mr. Chairman. I just wanted to say agree on all the points actually made. And I'm very much supportive of legalization and regulation, but there are steps that need to be taken to get to that, because regardless of how we got to this point, we are at this point. We are where we are. And especially, with substances being mixed in with other things and stuff like that, I think it's very important that we have the protections in place before we just outright legalize something. So I'll be supporting the ITL.
Thank you. And I would just, I would add that I would like to see this come back in some form in the future as a medical bill versus just a criminal justice bill. Representative Wheeler.
The substances are being mixed right now. There's only so much that we can do as a state to put in protections for people with substances like these. People will make them regardless of if they're illegal or not. They will attempt to concoct this substance using high school science class level knowledge, whether we legalize it or not. But if it's legal, then scientists who right now, professors who right now have an interest in studying it in New Hampshire schools will be able to pursue their interest without fear of the stigma, without fear of criminalization, without fear of arrest, and actually be able to move forward to get us to the position that Representative Newell is looking for. Legalization of these substances under this legislation gets us to the position that Representative Newell is looking for. So I will be voting against the ITL motion.
Thank you. And I look forward to hearing that compelling speech again on the floor. With that, I'll ask the clerk to call the roll. Motion on the floor is an expedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Lynn,
Yes.
Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Gathright,
Yes.
Representative Muse,
Yes.
Representative Bolden,
No.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes no. Representative Newell,
Yes.
Representative Brennan,
Yes.
Representative Wheeler,
Nay.
Chairman Roy.
Chair votes yes.
Motion passes 17-3.
Motion of inexpedient to legislate passes 17-3. Who would like to write the minority report?
So,
I will, Mr. Chairman.
Thank you.
Mr. Chairman, if I may, I just, what I was going to say was I have been approached and it's been specifically requested that we actually write down who is going to do the minority report, so that in the event that our committee assistant has to chase somebody down, she actually knows who she's chasing down, and about the manner of having them done, or they're unfortunately not going to be able to be in the calendar for the floor.
Thank you. Okay. Representative Pratt, will you be writing the majority report?
Yes.
Thank you. I close the executive session on House Bill 328. Open the executive session on House Bill 344. And I recognize Representative Reed to make a motion.
Thank you, Mr. Chairman. I move to retain this bill.
Is there a second? Seconded by Representative Gathright. Would you like to speak to your motion, Representative Reed?
Thank you, Mr. Chairman. I think we should retain this bill because there's a bill in Commerce already covering this, and we need to make sure where that bill's at because they may have stripped this part out. They may not have, so until we get a better handle on what's coming out of Commerce, I think we should retain this bill.
Thank you. Representative Gathright, would you like to speak to your second?
Well said.
Thank you. Further discussion, Representative Newell, I see you.
I'd just like to clarify that in, what is it, 638, the one that's in Commerce, it does not include the legalization of home cultivation. And so I really wish we could vote on this today, because if we don't, then we're just, this is not, it's a home cultivation is not going to be legalized if we don't vote on this.
Just to be
So-
clear, retaining it, we will, it doesn't mean that it's done. We have to act on it by October, so.
Okay.
Representative Murray.
Thank you, Mr. Chair. I was going to say the same as Representative Newell, that the home cultivation part of 639, I believe it was taken out, and we passed it on the floor without that piece yesterday. So I would support OTPing this bill today.
Thank you. I didn't realize we had so many green thumbs on the committee. Further discussion.
You don't know that.
Okay, seeing none, I'll ask clerk to call the roll. The motion on the floor is retained.
Vice Chair Rhodes,
Yes.
Representative Pratt,
No.
Representative Lynn,
Yes.
Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Gathright,
Yes.
Representative Muse,
Yes.
Representative Bolden,
No.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman,
Yes.
The clerk votes no. Representative Newell?
No.
Representative Brennan?
Yes.
Representative Wheeler?
Nay.
Chairman?
Chair votes yes.
Vote is 15-5.
The bill is retained by a vote of 15 to 5. I hereby close the executive session on House Bill 344 and open the executive session on House Bill 376 and recognize Representative Janvrin to make a motion.
Mr. Chairman, I move ought to pass.
Seconded by Representative Gathright. Representative Janvrin, would you like to speak to your motion?
Absolutely. Yeah, the stakeholders that came before this committee testified that there is no standard. If you go to the police have standards. If you go to the fire academy has standards. There has not been a telecommunications academy that once was held, I believe they said by the police academy, in many, many, many years. So I think that if we standardize the requirements and training for our telecommunications specialists, I'm not going to call them dispatchers, that it would make us all safer.
Thank you. Representative Gathright, would you like to speak to your second?
Was well said as well.
Thank you. Further discussion? I think this is a beneficial piece of legislation that's going to help the emergency community as well as the community at large. So I also endorse this bill as ought to pass. I would ask the clerk to call the roll, please.
Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Lynn?
Yes.
Representative Prue?
Yes.
Representative Janvrin?
Yes.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Stone?
Yes.
Representative Tensar?
Yes.
Representative Gathright? Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Brennan?
Yes.
Representative Wheeler?
Yay.
Chairman Roy?
Chair votes yes.
Motion is unanimous, 20-0.
The motion of ought to pass is unanimous. Any objection to consent? Seeing none, I'll go on the consent calendar. I hereby close the executive session on House Bill 376. Oh, excuse me. Yeah. What?
Mr. Chair, I apologize. I know I'm a guest here, but I do have to testify before education on another matter, and they texted me saying that they're kind of ready for me to go over. So I'm wondering if I could be excused.
How long do you need? About
Try to make it.
10 minutes?
Yeah, I would say about 10 minutes.
Okay.
And
Works for you.
Mr. Chairman, also the amendment that I requested has arrived, so I got to go up and make copies. So if we can do that.
Okay, let's take a 15-minute recess while we collect our amendments and the representative goes.
Thank you.
That's good because my amendment is jacked up too.
Yeah, mine's probably jacked up.
And did Karen say she needed the green sheets? Because I've been filling those out every time.
Yeah, who complained about that?
We haven't been putting who's going to be doing the minority report because often what's said is somebody will do it and then I guess it's not, it's just somebody may be doing it, but they're not coming in before the calendar needs to be in and then they have the whole
At this time, we're going to reopen the executive sessions. I believe that we had already opened the no, I was about to open the executive session on which one?
Do we need,
481?
thank you. Do we need Lynn?
Yeah, he's in the hall, I believe. Representative Tenzar, would you mind stepping out and see if Representative Lynn's out there?
So we back up.
At this time, I'm opening the executive session on House Bill 481 relative to arrest warrants, and I recognize Representative Janvrin for a motion.
Mr. Chairman, my motion is ITL.
Is there a second? Representative Peru. Representative Janvrin, would you like to speak to your motion?
Yes, the prime sponsor testified before us and explained his bill quite succinctly. One of the things that I noticed was the bill is seeking to stop police officers from judge shopping, I guess is the best slang to use. But what it doesn't take into account is that a justice of the peace can assign an arrest warrant. All they need to be is neutral and detached from the subject that's to be arrested. And that would allow, say, Portsmouth Police Department to go to Northampton Police Sergeant, who's a justice of the peace, and swear out a warrant for the arrest. If this bill were to pass, and the sergeant in Northampton says, I can't sign it because I'm not neutral and detached, I arrested him last week, now they have to go to another justice of the peace or justice of the court, and they'd have to make out a big long explanation that we went to this guy, he's a justice of the peace, and he didn't deny it, but he is not neutral and detached, so I can't issue the warrant. It's a very, very unfortunate that the bill came to us, because it actually makes it so much harder for a police officer to get a warrant, when honestly time could be a very, very big factor in getting that warrant. So I definitely would like to ITL the bill for that reason.
Thank you. Representative Peru, did you want to speak to your second?
I agree with the other representative, and I think it could cause undue delays in getting a warrant, and some confusion on it. So I don't think it's the right bill at the right time. Thank you.
Thank you. I would add that it seems to me on its face rather presumptive that there are judges within the court system that are willing to do things they shouldn't, so that police officers might be shopping for a certain judge. I think that's very presumptive, and I don't think that we should be thinking that way at all, barring some evidence that it has occurred or is occurring. Further discussion? Seeing, Representative Murray.
Thank you, Mr. Chair. I was just wondering if any of my colleagues could offer some clarification regarding my understanding of the bill was that it would simply request that information be shared, not necessarily that it would stop someone from being able to go to another judge to get the warrant approved.
Actually, yes. So in this situation, you're right, it would require that it be shared with every time you went to another justice, it would have to be shared to that justice. And the situation I explained, Portsmouth PD wants an arrest warrant. They go to Northampton. That sergeant says no because I know that person. I'm not neutral and detached. So now they go to Newington, and that justice of the peace says no, I know that person. So they go to, and they end up before a district court judge for the warrant, because no justice of the peace will issue it because they all know the guy. So now it's going to take that police officer valuable time to explain to the justice why none of these justices of the peace issued the warrant. So I think it's just very onerous for the police officer.
Further discussion? Representative Newman.
Yeah, just to follow up, is the significant thing that the judge in that situation that you described, or all of the people involved, knew the person, or is that they have to bring that type of information to the person? And if that is so, it's written, so wouldn't they just be taking the same information? I'm trying to figure out what the delay is.
Well, actually, I think in the way the situation I explained, it may not be that the justice of the peace. So if it goes to the justice and he says they have to give all that information, the assumption or the presumption by that justice may be that the others denied signing the arrest warrant because there was not probable cause, or there was exculpatory evidence or whatever. And that police officer, again, has to explain himself to that justice. I just think that it makes more sense that if the reason that they're not issuing the warrant is because they're not neutral and detached from the subject of their arrest warrant, that it really would delay having to explain to the next justice of the peace why they didn't get the warrant from the first.
Thank you.
I would add that it kind of, in a way, encourages police officers to have to inject hearsay into the warrant process. When they go to one judge, they have to say the reason they're speaking on behalf of the other justice or judge, and versus that person telling themselves. It interjects something into it that isn't there. We didn't hear from anyone about a case where this happened. We haven't heard really anything. This is just, it seems to me, a solution in search of a problem. So for that reason, I would definitely support the ITL on this. It's already a complicated process. And when you get into court after and you have defense attorneys looking at reasons to, and justifiably that's their job, to get their client off, and they can start seeing, wait a minute, this officer said this. Is that exactly what the judge told him? You're going to have judges subpoenaed into court as material witnesses as to why they didn't do it or didn't sign it, and it's going to complicate the process enormously. With that, I'd ask the clerk to call the roll.
Motion before us is ITL. Vice Chair Rhodes?
Yes.
Representative Pratt?
Yes.
Representative Lynn?
Yes.
Representative Prue?
Yes.
Representative Janvrin?
Yes.
Representative Mannion?
Yes.
Representative Reed?
Yes.
Representative Stone?
Yes.
Representative Tenzar?
Yes.
Representative Gathright?
Yes.
Representative Muse?
Yes.
Representative Bolden?
Yes.
Representative Bradley?
Yes.
Representative Murphy?
Yes.
Representative Newman?
Yes.
The clerk votes no. Representative Newell?
Yes.
Representative Brennan?
Yes.
Representative Wheeler?
Yay.
Chairman?
Chair votes yes.
Motion passes 19-1.
Motion of inexpedient to legislate passes. Do you object to consent? No objection to consent. It will go on the consent calendar. With that, I close the executive session on.
Should be doing a minority report.
Will you be doing a minority report, or just, you don't have to? With that, I close the executive session on House Bill 481. Open the executive session on House Bill 503 and recognize Representative Prue for a motion.
I move ITL.
Second?
Second.
Second to Representative Rhodes. Representative Prue, would you like to speak to your motion?
I see this bill as a way around how this legislature funds agencies, and it's kind of like a backdoor funding process for the crime lab. As much as I understand that they're probably underfunded and need more money, there's a budget process, and this kind of skips that. So I'm gonna ITL that.
Would you like to speak to your second, Representative?
Thank you, Mr. Chair. Pretty much exactly what Representative Prue said. I would just add that the department themselves have not seemed to, come to anybody asking for more funding. I think that would be the first step.
Agreed. Further discussion? Seeing none, I'll ask the clerk to call the roll. Motion on the floor is an expedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Lynn, Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Gathright, Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Brennan,
Yes.
Representative Wheeler. Chairman,
Chairman votes yes.
motion is unanimous, 20-0.
20-0, unanimously, inexpedient to legislate. Any objection or consent? Seeing none, it'll be on the consent calendar. I hereby close the executive session on House Bill 503. Open the executive session on House Bill 585. And Representative Tenzar, you have a motion.
Yes, Chairman, I move to ITL.
Is there a second? Second, Representative Stone. Would you like to speak to your motion, Representative?
Yes, thank you again, Chairman. While I appreciate the sponsor in filing this bill, I just believe that it is unnecessary and overly punitive in nature. The first part of RSA 105-20 Part 2, Roman numeral 4, is already being conducted by police standards and training. Subjecting an officer to a blood test with a mere complaint of excessive force violates that officer's due process and also could violate potential collective bargaining agreements.
Thank you. Would you like to speak to your second, Representative Stone?
Mr. Chairman, I would like to add that although this does have good intentions, the reality is most departments have a policy to establish drug screening if the department feels it's warranted under their collective bargaining.
Thank you. I would add that singling out a single substance and saying we're going to test for the single substance every time there's an allegation of this particular act. First of all, it just eliminates all other possibilities to that one. I think that should an investigation of an allegation lead to that point, then the local chief of police or whoever can investigate that aspect of it. But mandating that be part of an investigation before there's even any evidence doesn't make any sense to me at all. It's an expense, and to your point, it definitely would affect the collective bargaining agreements. Further discussion, Representative Newell.
I just wanted to clarify because what I have written in my notes is that what was testified to is that hiring standards can be adjusted to, and this is just my own wording, not like quoting, but hiring standards can be adjusted to include steroids and drug tests. So to me, I'm thinking, that is a good part of the bill. I think that that's a good thing to be part of the standards and training. My question is that Representative Tenzar was saying that it is already part of that, and I just wanted to clarify whether it is or if that's something that's being considered to be added.
Thank you. Representative Stone, did you want to reply to that?
Mr. Chairman, I would. Initial drug screening is done during pre-employment already, so it's up to the police standards and training and the hiring agency to review what drugs they want to be screened for at the time of conditional offer of employment usually.
Director Skip, would you like to add to this before we come to a vote? Did you have anything you wanted to add to that regarding what's going on with the standards and training with regard to that?
Thank you, Mr. Chairman. Thank you, ladies and gentlemen. John Skippa, Director of Police Standards and Training, for the record. Representative Stone is correct that we do require that a drug screen be part of the hiring process. It's captured in RSA 106L. We can do a better job of establishing specific elements to test for in our administrative rules, which, based on the movement of this bill, is something I'm going to bring back to the council just so that we're making sure that that is actually being looked at.
Thank you. The committee appreciates your input, and anything that can be done be rules instead of statute, I think is much better because it's much more flexible to be adjusted. Thank you for adding to that. Anything further? Seeing none, I'll ask the clerk to call. Oh, what did I miss? Oh, sorry, Representative Muse.
I just I just wanted to add that one of the things that's kind of swaying me is the fact that we really would be taking away the due process rights of an officer if we simply require them to to get this test after any excessive force complaint, and we took action without any kind of a hearing. So basically, if there's an excessive force complaint against you and you test positive, you're out. It just seems to be a pretty big step to take, in addition to some of the other arguments we've heard.
Thank you. The point is well taken. At this point, I'll ask the clerk to call the roll. The motion on the floor is inexpedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Lynn,
Yes.
Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Gathright, Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Brennan,
Yes.
Representative Wheeler,
Yay.
Chairman.
Chair votes yes.
Motion is unanimous. 20-0.
20-0, inexpedient to legislate. Any objection to consent? Seeing none, we'll go on the consent calendar, and I hereby close the executive session on House Bill 585. Or was that 35? Yeah. And I open the executive session on House Bill 589. And I recognize Representative Janvrin to make a motion.
Thank you, Mr. Chairman. I move inexpedient to legislate.
Seconded by Representative Gathright. Representative Janvrin, would you like to speak to your motion?
Absolutely. So this here seeks to make, well, we know what it's, I hope we understand the bill. As a person who utilizes free software, open source software, there are times when a developer may infringe on copyright, and to tie the hands of our police and at the state and local level is kind of overboard. I'll use a couple cases about copywriting. Hampton Beach, I represent Hampton. At Hampton Beach, we have people that come in and infringe upon trademarked sports gear that sell it there. And there are several times where they've been ordered by a court to seize that. And I see this bill as saying, in that instance, the police officers can assist. So I don't see us getting involved in this. I mean, because it has a criminal penalty attached to it, it came to our committee, and actually might have done a better job in commerce. But I'm definitely opposed to the premise that our local law enforcement, and especially the sheriff who deals with civil law, and this is a civil matter, not a criminal matter. I think that it just needs to die on the tree it came from.
Representative Gathright, would you like to speak to your second?
Yeah, I just found it to be sort of confusing because it's an open source, but I thought that was the purpose of the software, but other than that.
Thank you. I would just say that I think we have enough criminal laws, and we should not be getting into tort law and making it criminal. So, anyone further discussion? Seeing none, I'll ask the clerk to call the roll. The motion on the floor is inexpedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Lynn,
Yes.
Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Gathright,
Yes.
Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The chair votes yes. Representative Newell, sorry, the clerk. Representative Newell,
No.
Representative Brennan,
Yes.
Representative Wheeler, Chairman Roy.
Chair votes yes.
Motion passes 19-1.
19-1. Representative Newman, do you object to consent? Seeing no objection to consent, we'll go on to consent calendar and expedient to legislate. I hereby close the executive on House Bill 589 and open the executive session on House Bill 421 and recognize Representative Rhodes for a motion.
Thank you, Mr. Chairman. I would like to make a motion of ought to pass, offer amendments. You guys all have it on your tables. It is 2023-0450H.
Is there a second? It's yes, the motion is adopt the amendment. Is there a second? Seconded by Representative Reed. Would you like to speak to your motion?
Yes, thank you, Mr. Chairman. This was the bill that came to us about incarcerated women and hygiene products. We had a subcommittee on it, and the amendment in front of you is the result of everybody that was on the subcommittee and also the stakeholders that were here to offer their expertise on the situation. We all went over it. When I say with a fine tooth comb, I mean down to how we actually put the sentences in order. And we addressed all of the situations that were brought to our attention that we all found pretty egregious, and we fixed that. So I would just ask everybody to please support it.
Would you like to speak to your second, Representative Reed?
I concur with Vice Chairman Rhodes.
Thank you. I would ask Representative Rhodes, did the Commissioner Hanks endorse this as it is?
Commissioner Hanks had her, I would say, associate was there that day, and this was actually a lot of it was written with her here.
Thank
So
you.
the answer to that is yes.
And did you invite representatives from the county correctional facilities?
Yeah, thank you, Mr. Chairman. Yes, an email was sent out to the counties, and I was actually given that information from the stakeholders to make sure I had the right addresses, so everybody that was here had their input.
Did anyone from the counties come?
I do not believe so.
Okay, thank you. I'll just say that I think that the testimony we heard was for lack of a better term, horrific. And I'm glad that we were able to come together on a piece of legislation to fix it. I'm extremely disappointed that no one from the counties came, but they did have their opportunity. So having said that, anyone else? Representative Wheeler.
Totally agree with what you said, Mr. Chairman. The testimony that we heard in regards to this bill was appalling, and the fact that that's going on in our county jails is appalling. And I know I'm on my county delegation, and I will do whatever I can to investigate that further, and hope anyone else who is on their county delegation or who knows the representative in their district who is, that they would ask that they do the same.
Thank you. That's well taken. Anyone else? Representative Bolden.
I'm not one to defend the county prisons or jails, but I do think in their defense that they were present for the initial subcommittee meeting. Oh, specifically a lobbyist representing them was sitting next to, if I remember correctly. And I think she was fine with everything too. She was
Yeah.
she participated.
That's what I was asking. I couldn't.
Did they offer any
Census
input
hearings.
as to what's going on in their facilities?
She participated in the conversation. It's been a couple weeks and I'm pretty tired, so I don't know.
Okay. I'll take it that it was impactful testimony. Seeing no further discussion, I would ask the clerk to call the roll. The motion on the floor is the adoption of the amendment.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Lynn,
Yeah.
Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzai,
Yes.
Representative Gathright,
Yes.
Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Brennan,
Yes.
Representative Wheeler,
Yay.
Chairman Roy.
Chair votes yes.
Motion is unanimous.
The amendment is adopted. Representative Rhodes, do you have a motion?
Yes, thank you, Mr. Chairman. I move ought to pass as amended for House Bill 421.
Second. Nancy second.
Seconded by Representative Murphy. Representative Rhodes, would you like to speak to your motion?
No, thank you, Mr. Chair. I think we've summed it up.
Representative Murphy? Anyone else? Seeing none, the motion on the floor is ought to pass as amended. Now, I would ask the clerk to call the roll.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Lynn,
Yes.
Representative Prue,
Yes.
Representative Janfrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Guthrie,
Yes.
Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Brennan,
Yes.
Representative Wheeler, Chairman Roy.
Chair votes yes.
Motion is unanimous.
The motion of ought to pass as amended carries unanimously. Any objection to consent? Seeing none, it will go on the consent calendar, and I hereby close the executive session on House Bill 421. I will now open the executive session on House Bill 135, and I recognize myself to offer an amendment. I am offering amendment number 0684H.
Second?
Thank you. I will speak to the amendment. The amendment basically adds a section to this bill. This bill was brought to us to ban no-knock search warrants. We heard testimony from law enforcement that it's basically not being done now with regard to evidentiary purposes. The public doesn't want these. They oftentimes result in injuries to either officers or people. We ask the police to carry out and enforce the laws that we write. And in so doing, we have to ensure that we give them the tools to do it, while at the same time balancing that with the rights of the public to be safe. And I think this bill accomplishes that. What this amendment does is basically almost verbatim takes the policy of the United States Department of Justice pursuant to President Biden's executive order on no-knock warrants and adopts it and applies it for the state. What it does is it bans no-knock warrants except for in the case of a law enforcement officer's safety or the safety of someone there. I think that's pretty self-explanatory. It requires them to get permission from their chief law enforcement officer. It also has an exception if the officer does not have a no-knock warrant, but upon arriving to execute the warrant, they discover that evidence exists that would make the no-knock warrant necessary, again, only for safety purposes of someone there or the officers. Again, I think that's self-explanatory. There is one exception for evidentiary, and that's an extreme exception. That would be, for example, and this isn't limited to that, but it's an example, if they discover there's someone's been kidnapped or there's evidence of human trafficking, and if the officers were to knock and announce, there's a great possibility that the evidence could be destroyed, which could locate a missing person or a trafficked person. They can get a no-knock for that, but we have put a pretty high bar. They have to get permission from their chief law enforcement officer and from the district attorney or the attorney general as their designee. So this sends a clear message that we frown on no-knock warrants except for in extremely limited circumstances. And with that, I open it for further discussion. Representative Wheeler.
Question to the chair. So, to clarify, if a law enforcement officer felt that his safety was in danger, he could pursue a no-knock warrant.
In pursuant to the second exception, If an officer has a regular search warrant that's not a no-knock warrant, they go to execute that warrant, and they discover when they get there, before entering, that there's a violent person who may have a firearm. In order to keep them from having to leave and go back and get the no-knock, they can execute a no-knock at that point. They have to immediately report that they've done so to the chief law enforcement officer, who has to also report it to the district attorney. And they have to articulate why they felt that that was very necessary at that time. But that's the only exception. They would not be able to show up and say, well, there's more evidence and we're going to lose the evidence, so we're going to do a no-knock without permission. That they can't do. Only exigent circumstances where when they get there to do the warrant, they see this could be dangerous if we knock and that guy knows we're out here. Does that explain it?
It does.
Representative Mannion.
Thank you, Mr. Chair. Before I start, I just want to let everyone know that I've been in law enforcement about 30 years. I'm retired. However, I still work in a part-time capacity before I speak on this. But we heard testimony, and I can tell you, and it's been in my experience, that these no-knock warrants or any high-risk warrants are done by specialized teams. It's not two officers that are going to show up and kick a door in. It's specialized teams that are trained. There are supervisors that supervise those teams. And we heard testimony from Manchester that, contrary to what we see on TV, they don't kick doors in wearing black clothes and masks and rush in and grab someone. They open the door, they breach the door so they can get a look inside before they make entry. And that's generally how it's done today, in my experience, and we've heard testimony on that. That's so they can take a look in the house before they make entry, and they announce themselves before they go in. They don't just kick the door in and rush in. So, and that's my experience, and that's what I think we've heard as testimony is how it's done. So, what we see on TV is not necessarily how it's done in New Hampshire. Thank you.
And I definitely agree. That was the testimony we heard. And all this bill does is really just codify what they're already doing. Representative Newell.
I guess, you know, what I would say is that I just hope that there is a really high bar for taking that action. And it seems like you've written that into this amendment. And so I'm going to vote for it. I hope that as it's implemented, it's abided by in that way, that we really reserve that for extreme situations like that.
Thank you. And I also wrote into the bill that when a warrant like this is executed, once the return is made, that means when they give it back to the court and say, this is what we did and this is what we found, it becomes immediately public information so that we can watch and see, and the public has a full view of what's going on. Further discussion. Representative Muse.
I just wanted to say that I'm going to support the bill, and one of the reasons for that is I don't think we should try to toss out the good in quest of the perfect. I'd be the first to say that I have some concerns about some of the exceptions. I have concerns that the language may be a little bit tough for individual officers to interpret, but I think we owe police standards and training in the local agencies the benefit of a doubt when it comes to properly communicating what the guardrails are around this process. So with that in mind, I plan to support it, and I hope that the statute has its intended effect.
Thank you. And if it doesn't, we'll be here to fix it. Representative Pratt.
I studied the original amendment. Can you tell me what the difference is between 0684 and 0681?
Yes,
been
at
through
the
three
request of
revs.
the state police, the sentence that said if no one answered would cause them, it had the inadvertent effect of it would actually freeze them in place. If no one answered the door, they would just be stuck there. They wouldn't be able to execute the warrant. I don't think that was the intent. And also, I did increase, it said next business day on page 2. And at the request of Chief Bronowski, I extended it to 48 hours just because it can be difficult in the North Country for them to track down a district attorney to make this report too. Or if it's on a weekend, it just gives them another day. Representative Reed. Excuse me, Rhodes.
Thank you, Mr. Chairman. I just would like to add that I'm actually very, very happy that the exception for human trafficking or any missing persons was made sure to be an exception so that we can do everything we can do to help save these people.
Thank you. Nope. Representative Murphy, I'm sorry.
Thank you, Mr. Chair. I just wanted to say I will definitely be in support of this amendment, because I think it actually um, it, it benefits both the public and law enforcement, the best interest of both. So I'm definitely in support.
Thank you, Representative Murphy. Representative Newman.
Yeah, I just have a quick question about the only authority that they have to see is that the chief of the department, if they make a request when they have to use one because there's danger to a person. I just wanted clarification. We also heard testimony here that, or comments here, that for the no-knock warrant they use a lot of times special SWAT operations or whatever they do to accomplish that. And is that what you think would happen if let's just see how often they do that kind of thing, get the special people to do it, or are there circumstances where it would be just plainly obvious that a no-knock warrant should be administered by the police that are there?
So as part of the exception, one of the exceptions is if they have a regular search warrant and they arrive and it becomes obvious that a no-knock would be necessary, this authorizes them to do that. And upon doing that, they have to make an immediate report to the chief law enforcement officer what they did and why they did it, and also has to be notified to the district attorney as well. So there are checks and balances in there. With regard to the specialized teams, they still have to go through the same procedure.
Okay.
Maybe I didn't understand your question.
No, and I don't blame you for that. It was kind of convoluted. But I guess they had, in that circumstance that you just described, they would still have to make a call to at least their chief of police to then execute it instead of. Thank you very much.
Actually, no, I want to correct that. No, they don't. They can make the call at the scene themselves and immediately after have to, because you're talking about minutes, seconds. When you get ready to do a door and you see there's someone with a gun, you can't pause and make a call. And but immediately upon doing it, they have to report it.
Thank you.
Thank you. Representative Stone.
I'd just like to follow up, based on my former occupation. I used to carry out no-knock warrants in addition to regular announce-it-a-knock warrants. And there's an operational plan that gets in place before you even execute the warrant. Your chief of your department, I can't think of an agency in New Hampshire where a chief wouldn't know that a search warrant wasn't being executed in his jurisdiction by even an outside agency such as the DEA or ATF. So there's a lot of things in place. The operational plan obviously calls for additional resources such as EMS on standby. And there's quite a checklist that goes down before these warrants are actually carried out. And like I said, the chiefs of police usually are very aware that this is being conducted prior to the warrant being executed.
Yeah, and I would think there'd be something to pay if they weren't. Representative Newell.
I just wanted to clarify, and forgive me if this has already been stated, but clearly, if the situation is that when you get there and you realize that there are exigent circumstances that would create an imminent threat of physical violence to the officer and or another person, they would need to immediately notify his or her chief law enforcement officer, who shall provide written notice to the district attorney. So it's notify, but it's not necessarily get permission in that moment, get authorization, but it is the officer making the officer's discretion and good judgment, right? Notifying, and then obviously that's public record and all that kind of stuff.
Thank
I just
you,
didn't hear that
and-
clearly, so I wanted to
Yeah.
throw it out there.
And also, as we know, it's not going to be, two brand new patrolmen out there. You're going to have a senior officer on scene who's in command of one of these teams. So the chiefs will certainly have a responsible person there to make this kind of call. And the chief will be notified right away, and so will the DA. Representative Wheeler.
Mr. Chairman, I'm a little concerned that this bill doesn't change anything. I really agree with Representative Rhodes about the section including human trafficking, and I really want to do everything that we can to get to deal with that, because that's one of our larger issues that we face today. But I'm a little concerned that this is just up to the discretion of the officer, and thus for they would have no real recourse. The officer could just say that his safety was at risk and move forward with the no-knock warrant. And I just don't see this as actually addressing what the intent of the bill was, which is to prohibit no-knock warrants. And I think that there is good reason to do that, and I'm not sure that allowing the leeway to still pursue one is the right way to move forward. But I'd be interested to hear your response to that.
Yeah, absolutely. I think when we look at things like this, we have to look at imagine if we didn't. So if you can for a moment, picture yourself on the scene about to execute a search warrant. You're all ready to go. It's a knock and announce. And you, through a window or through whatever intelligence, someone on the inside discover there's a gentleman in there, a gentlewoman in there who is armed and is likely to fire on you when you open the door and announce that's the only discretion they have, is to say, oh, and they have to articulate it. They can't just, like you said, well, I felt unsafe. It's going to be a clearly articulable reason. So if we go with the what if we didn't, they would have to open the door and say police, and they're going to get gunfire. I think that the extremely limited case of allowing that and making them have to explain it in depth to not only their chief, but the district attorney afterwards, it gives the public a chance to see what they did and why they did it. It's no longer a secret. And I think it's the potential for harm is greater if we don't allow that exception than it is if we do. And if, to your point, it becomes apparent that has been abused, we could always strike that later based on evidence. But right now there's no evidence of that. So I don't want to limit that based on no evidence, only conjecture. I think this does change what's currently going on insofar as, even though we hear it's not happening, now we have a clear procedure in place when it's authorized and when it's not. And also we have now open window for the public to see, whereas before it was a little more onerous to get these documents. Now they become public right away after they're done.
Follow up, Mr. Chairman?
Absolutely.
I really appreciate that. And hear your side of, I think, Mr. Chairman, based on the fact that you likely have the votes on this amendment, I'm probably going to vote against it. I was someone who, I remember very clearly the no-knock warrant that I went through as a child. And I just think the practice itself is so flawed that allowing the leeway to continue that practice in any way whatsoever, I just want to go back to the time when it wasn't even legal. And I think that that's what the original bill does. So given that you have the votes, I think on principle, I'll probably vote against your amendment with respect.
No offense taken, and that's why we're here to discuss. And I appreciate your experience brought to share with the committee. Representative Prue.
So I know I'm only on the fire side, right? I'm a deputy chief. And I know if I have people under me that aren't following the rules, God help them, right? Because it's almost more wrath than what the other law would do for you. And I'd like to hear how you would get in the house without getting shot.
Well, I'm not a law enforcement officer, Representative Prue, and I don't claim to know law enforcement strategy, but frankly, I do agree with what was brought up in public testimony and the questions. I think that there are other ways to arrest the person. It doesn't have to be when the person's in the house. I think very few human beings are all the time 100% in their house, and law enforcement could, through the myriad of surveillance technology we have right now, find that person when they're outside of their house and arrest them then. And of course, if that person has committed a provable heinous crime, that their house could be searched and seized after that person has been arrested on the street.
Thank you.
Happy to do it.
I appreciate the discussion, and I recognize your position, Representative Wheeler. I think I'm happy that you added to the discussion. But having said that, I think we've discussed this quite enough. I think that we all know our positions on it, and I hope that the majority of the subcommittee adopts the amendment. And I think that's where we are, right? We're,
Yeah.
yeah, okay. I'll ask the clerk to call the roll on the adoption of the amendment.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Lynn,
Yeah.
Representative Prue,
Absolutely.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Gathright, Representative Muse,
Yes.
Representative Bolden,
This is the amendment, right?
Yeah.
No.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Brennan,
Yes.
Representative Wheeler,
No.
Chairman Roy.
Chair votes yes.
Motion passes 18-2.
With that, the amendment is adopted. At this time, I will recognize myself to make a motion of ought to pass as amended,
Second, Mr. Chair.
seconded by Representative Rhodes. I don't see that we need much more discussion. I think we've delved into this pretty deep. I would just respond to Representative Wheeler's sincere concerns. I anticipate he and hopefully I will be here for some time to come, and if we need to readdress this, I'm happy to work with you to do so. Having said that, I will ask the clerk to call the roll. Ought to pass as amended.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Lynn,
Yes.
Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Gathright, Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes no. Representative Newell,
Yes.
Representative Brennan,
Yes.
Representative Wheeler,
Yay.
Chairman Roy.
Chair votes yes.
Motion passes 19-1.
Representative Murray, would you object to consent?
I do not.
Thank you. There being no objection, this will go on consent, and the bill passes ought to pass. With that, I will open, what's the last one we have?
I'm sorry, Mr. Chairman. I was not paying attention. I object to this being on consent, if it's
Oh,
still possible.
But you voted yes.
Oh, I did vote yes. Object to it. I objected to it.
Do you want to reconsider your vote?
If I could. But Ally could just also object to it being on consent as well.
Okay.
We wouldn't have to go through the procedure.
Yeah, that'll just save you from having to pull it after, so yeah, okay. It will not go on consent. And Representative Wheeler will write the minority report since you're going to speak on it, right? Yeah. Okay. So moving on, what's,
would have been.
yeah, yeah.
130, 156.
Yeah. What's left?
Yeah, 156.
I open the executive session on House Bill 156 and recognize Representative Janvrin to make a motion. A motion.
Mr. Chairman, I move Amendment 2023-08, I'm sorry, 0682.
Is there a second?
Second?
Seconded by Representative Muse. Representative Jan, would you like to speak to your motion on the amendment?
Yes, the amendments before you, it actually changes section 1 of the bill. And what it changes is it makes misconduct could be described as intentional misrepresentation of a material fact in the police report as described in RSA 641:3. 641:3 is unsworn falsification statute, and it defines this very well. So I think that removing what was in the original bill and replacing it with this still encapsulates most of what was in the original bill, but it just cleans up the language and makes it a little bit easier to understand.
Thank you. Representative Muse, would you like to speak to your second?
Yes, I think that the amendment actually does capture the intent of my original bill. The part that actually is missing is specifically calling out misidentification of a person. But if you take a look at the statute, intentional misidentification of somebody's ethnicity, gender, or race would actually be covered under the statute. So what we're in effect doing is really elevating the intentional misrepresentation of a material fact in a case to a form of misconduct, and we're actually including that in the definition. And what that will effectively do is for police officers who are charged with that and who go through the process, one of the things that will do, it will make it it'll make it the kind of an offense. Sorry about that. It will make it the kind of offense that could lead to a suspension of certification or loss of certification, depending on the severity of the issue and on what's found. So I think this bill was actually intended to address a very serious issue, and I don't think it will affect 99.9% of law enforcement officers. But for that 0.1% who might be thinking about doing something like this, it sends a pretty strong message that we take this seriously in New Hampshire. Thank you.
Thank you, Representative Janvrin and Muse, for that. I always take extremely seriously any bill that would in any way target the people that we charge with enforcing the laws that we make. Having said that, I believe that there's not a chief of police in this state who would not take disciplinary action against one of his or her officers for an intentional misrepresentation of fact in any report or document. So I think this is, again, just a case of codifying something that is already being done, and it sends, to your point, a good message. Further discussion? Seeing none, I'll ask the clerk to call the roll on the adoption of the amendment.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes on the amendment.
Representative Lynn,
Yes.
Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Gathright, Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Brennan,
Yes.
Representative Wheeler,
Yay.
Chairman Roy.
Chair votes yes.
Motion is unanimous.
The
20-0.
amendment is adopted unanimously. Representative Janvrin, would you like to make a motion?
Yes, Mr. Chairman, I move House Bill 156 ought to pass as amended.
Second? Anyone?
Sure.
Seconded by Representative Prue. Representative Janvrin, would you like to speak to your motion?
I think we covered it.
Thank you, Representative Prue.
Ditto.
Further discussion? Seeing none, I'll ask the clerk to call the roll. It's now ought to pass as amended.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Lynn,
Yes.
Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Gathright, Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Brennan,
Yes.
Representative Wheeler,
Yay.
Chairman Roy.
Chair votes yes.
Motion passes 20-0.
Motion passes, ought to pass. Any objection to consent? Seeing none, it will go on the consent calendar. And I close the public hearing on House Bill 156. What? Excuse me, executive session on 156. With that, I will open the executive session on House Bill 593. And I'm going to recognize myself to make a motion. I had hoped to have a conversation with the prime sponsor of this bill. I have not seen him this morning. Having said that, this bill is a very complicated bill, and it certainly deserves more than the week of time we've had to digest it. There is a lot of work needs to be done with the court system, with the police, with the sponsor. So I'm going to move to retain this bill, to give it a chance to be worked out so that we can hopefully get buy-in from everyone who this would affect, rather than just pass it or kill it.
And
I
Mr.
think
Chairman, I'll second your motion.
Thank you. I appreciate that. I should have asked for that first, but the retroactive second is appreciated. So with that, I would open it up to further discussion. Representative Murray?
Thank you, Mr. Chair. I just wanted to make sure that the committee was aware of two amendments that were offered to us by the sponsors of this legislation that I'm happy to forward to the rest of the committee. And also the co-sponsor of this bill is in the room right now if we do have any further questions.
Thank you, and I think that underscores my point. I haven't seen the amendments. I think this is a complicated bill, and I think it's going to require a full committee work session. I know there was a subcommittee to look at it, and frankly, I don't know that they were able to make enough headway that we can clearly understand the implications of what it will do in the court. I don't think was quite on board yet. Representative Rhodes.
Thank you, Mr. Chairman. I'd just like to reiterate what you just said. We did have the subcommittee meeting on this, and the subcommittee did unanimously vote to retain it, pretty much for all of the reasons that you just said. And it is very hard for me to sit in the Criminal Justice Committee and make this kind of a vote when, quite frankly, I feel like I'm out of my league. And I don't think that's fair to the sponsors or anybody else that it would involve. So, what would happen to it after it's retained? I don't know if Representative Lynn would be better in his committee, but I definitely feel like I feel like a fish out of water, to be quite frank.
Thank you. I think that applies to anyone who read the bill. It is complicated, and we will work probably with judicial. I don't think that at this point there's any advantage to try and move it over to judicial. We'll just work with them at the same time. And see, Representative Lynn, would you like to speak to that?
Yes, thank you, Mr. Chair. I agree. I'm going to vote for the retention because I think the points you make are valid ones. There's not in no way the fault of this committee. I think we had some bumps in the road as we were kind of working in a group to getting this together, and I'm how that happened is not really particularly important, but I do think that there are things that that we need to confront, and I'll just give an example. Chief Profonsky, who I know is in the room now, raised what it seems to me to be a very legitimate point. He indicated that he read the bill, the part that deals with what's been referred to as adoptive forfeitures, that he read the bill to mean that if we were to pass the bill, that if there was a situation of a local law enforcement agency that without any federal assistance made a drug arrest, let's say, and then decided, and presumably this would be because it turned out that there were a lot more drugs there than they anticipated, or some other factor. At any rate, they made the initial arrest on their own, and then they decide after that to refer the matter to the federal government, not just for a forfeiture, but for federal prosecution. He indicated that he read the bill to say that even in that circumstance where the whole case, including the prosecution and the seizure, were referred to the federal government, the state wouldn't be able to do that. In other words, I certainly had never intended. I don't think I had read the bill that way, but the fact that he has a, you know, a different view of it means that we at least need to think about that. Maybe we need to put some language in, because I certainly, I mean, I can remember from my days as a prosecutor that it was not at all uncommon for us to, in the U.S. Attorney's Office, to take a case that the state referred to us, where DEA or the ATF, the feds had no involvement prior to the case being referred, but then to take it for federal prosecution. And I certainly would not want to do anything that would prohibit that, because I think that happens with some regularity, and should be allowed to continue to happen. What I think, my intent anyway, and I think the intent of the other people that sponsored this, was to prevent the situation of a case that is a wholly state case. It's prosecuted in state court. There's no there's no involvement of the feds in the actual criminal prosecution of the defendant, but then the forfeiture is simply referred to the federal government. Now, I know from my discussion with Chief Brofonsky, it may be that law enforcement objects to even that being prohibited. And if that's the case, I have to say I do disagree with him on that. I do think that there's a genuine reason to prohibit a case where there's simply local involvement in the prosecution, to then refer that to the feds for the forfeiture only. I do think that there's a reason to prohibit that. But the very fact that we're having, you know, I'm sort of giving you this explanation suggests that we need to do some more work on this bill, so that we make sure we're all sort of on the same page. And to the extent that retention will allow us to get there, I can certainly support that.
Thank you. And coming from the former Chief Justice of the State Supreme Court, I'm thoroughly confused now, so that's good. I think we definitely need to retain this bill. Any further discussion? Representative Newell.
I would just like to find out if your view is that a retention would allow this bill to be worked on by the appropriate people to come together with the appropriate outcome.
That is absolutely my intention. I plan on making sure everyone at the table understands this and has at least some type of an agreement on how it should proceed.
And I think that was a more concise question.
It was actually very good. Thank
And
you.
I would say, to the extent of, you know, judiciary, we're happy to work with you on this. I have no problem. And I'm sure Representative Popovich Muller who's here, would also be willing to work with us on that, as well as Representative McGuire.
That is good to know, because we will definitely be using that resource. Representative Jambrin.
Thank you, Mr. Chairman. As most of you would recall, before I took a break from the House, I actually served on Judiciary Committee for 4 years. And in those 4 years, a bill similar to this came to us twice. And my recollection, we can have our researcher look at it, but my recollection was a bill almost exactly verbatim to this bill came before Judiciary in 2019. And the committee amended it to divert the funds that were taken by any forfeiture to a different use, and that's why the bill failed. But I remember that Judiciary had, because it was a civil matter in that bill, not a criminal matter as is in this bill, that there were several people that served on that committee and are still serving on that committee that would be very beneficial. Their recollection of this subject matter would be very useful to a subcommittee of our committee that works on the retainment of this bill. And I spoke with Chairman Lynn prior to us convening this morning, and I think it might be worth it to, as he said, they would be willing to work with us. We appoint a subcommittee and ask the speaker or the chairman of Judiciary also to assign some members of his committee to work with us, so that we actually have subject matter experts working on this, so we don't have to all be schooled in civil law.
All I heard is I volunteered to chair a subcommittee. Was that what everyone else heard? I think. Yeah, I think so. Yeah. Okay. With that, I'm going to ask the clerk to call the roll on retention.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Lynn,
Yes.
Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Gathright,
Yes.
Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Brennan,
Yes.
Representative Wheeler. Chairman,
Chairman votes yes.
motion is unanimous, 20-0.
And House Bill 593 is retained. Stand by for information forthcoming in the next week on subcommittees and things like that. And I close the executive session and stand by before we break.
Janvrin.
At this point, I'm going to open an executive session on a bill that we had already opened and or was I don't recall if we opened or not, but it was scheduled. It's House Bill 653. I'm going to open the executive session. I have discussed it with the Representative Gathright, who agrees to open the executive session on this now. And I'm going to recognize myself for a motion to retain. Seconded by Representative Gathright. I'll speak to my motion. This is another bail bill. We've discussed what we're going to work on this bail issue over the summer. We already have a study committee or commission formed out of one of the bills, and it's my intention to take pieces from all the bills and work with them. And there's also another bill that is almost identical coming out of the Senate. So I think that with all these bail bills flying around in the orbit, we need to collect them and clean them up and take a serious look at it. As well as some of you are aware, I'm working on a technology issue that's going to assist with this as well with the state police. So with that, I'm going to open it up for further discussion.
I believe it was well said. From the very beginning, we realized that we have quite a few bail bills, and we do want to do due diligence with the right thing to do and the correct process for everything. So I agree 100% with our chair.
Thank you. Again, I just want to be clear to the sponsors, to the people here, to the public. We take this bail issue very seriously, and we are going to work on it, and we will produce a piece of legislation this year. But we want to be measured, cautious, and ensure that everything's covered, while at the same time making sure that we're not violating anyone's rights. So I want all the stakeholders to agree on whatever piece of legislation comes out. So with that, I'll ask the clerk to call the roll on the motion to retain House Bill 653.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Lynn,
Yes.
Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Gathright,
Yes.
Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes no. Representative Newell,
Yes.
Representative Brennan,
Yes.
Representative Wheeler,
No.
Chairman Roy.
Chair votes yes.
Motion passes 18-2.
Is there an objection to consent, Representative Wheeler or Representative Murray?
It's retained.
Oh, yeah, never mind. I don't care then. With that, the bill is retained. And our business for the day is concluded. Thank you for attending and all of your input. And pay attention to your emails. We're all off next week. We are having our tour of the Department of Corrections on Wednesday. So if you are interested, it is a voluntary thing. I know some of you have said you can't make it, and that's regrettable, but that I got to do it that day. So look for email from me today that explains what time and where to meet, and we will take our tour of the male and female facilities. And
Question.
Go ahead.
Thank you for making exact 2 hours. That's all.
Oh, hey, do the business. Get out of here.